Difference between an invitation and invitation offer and invitation to make an offer. In section 2 of the India of the Act, the offer is final expression of willingness by the offer to bound by the offer. Should the other party choose to accept it, the other party choose to accept it. One of the other hand, offer made with the intention to negotiate or offer to receive offer are known as invitation to offer. Thus, where a party without expressing his final willingness propose certain terms on which is willing to negotiate, he does not make an offer, but only invites other parties to make an offer on those terms, hence when only thinks that is required willingness of the offeree to abide by the terms of the offer in order to ascertain whether a particular statement amounts of an offer or an invitation to offer. The test would be intentions with such a statements is made from mere statements of lowest price which the vendor would sell contains no implied contracts of the difference between an invitation to offer and a prospectus by recommending the public to subscribe for a share display of the receivable goods for sale of window shops window. Relationship between advertisement, auction sale, quoting of the price and in the reply of the query regarding the price offer. Section 2 of the acts an offer is final expression of willingness by the offerer to bound by the other party, bound by the offerer should the other party choose to accept it. If a person who makes the statement has an intention to bound by the person as soon as the acceptor, as soon as as soon as it's as the other acceptor, he is making an offer. An offer cannot be contract precedent to invitations to offer. Where a party without expressing his final willingness propose certain terms on which he is willing to separate, willing to negotiate, he does not make an offer but only invites other party to make an offer on those terms. A person who has intentions of negotiations on the terms he is called invitation to offer. An invitation to offer is always an act of precedence to offer. Offer can be made by act, absenteeism, word, conduct, written, oral. Acts. Acceptance. Definitions of acceptance in terms of section 2 of the terms where a party without expressing his final willingness propose certain terms on which he is willing to negotiate. It does not make an offer, but only invites the other party to make an offer on those terms. If a person has intention of the negotiations on the terms, it is also called invitation to offer. An invitation to offer is always an act of precedent of offer. Act absenteeism, words, conduct, written or acceptance. Definition of acceptance. In terms of section 2B of the Act, the term acceptance is defined as follows. When the person to whom the offer is made signifies his assent to proposal is said to be accepted. The proposal when accepted becomes a promise. Analyze of the above definition. When the person to whom the offer is to whom the proposal is made, for example, if a offer to sell his car to B for 2 lakhs, his proposal is made to B. The person to whom the proposal is made, that is B. In the above example, if B signifies his consent on that proposal, then we can say that if B has signified his consent on the proposal made by when B has signified his consent on that proposal, we can say that proposal has been accepted. Accepted proposal become promise. Relationship between offer and acceptance. According to Sir William and Sons, acceptance is offered with a lighted match of train of gunpowder. मतलब एक ट्रेन में बारूद भरा है और एक हमारे हाथ में लाइटर है, हमने जला दिया और ट्रेन में फायर लग गया. It is called acceptance. When we offer, then it will acceptance. It will nothing happen. You can't revoke it. And the effect of this observation is that acceptance triggers cannot be recalled or undone, but there is a choice to person who had the claim to remove it before the match is applied. If it is, it in effect means that the offer can be withdrawn just before it is accepted. Acceptance converts the offer into a promise, and then it is too late to revoke. Then it means soon as the flame of gunpowder is lighted, and it would be explode. If the offer has been accepted, it would be explode. You can't revoke it. It is on the other party to revoke if you wants to. You both have to communicate. If he don't want to revoke, then you can't do anything. Because this is a legal contract. But it's light in match acceptance. When the cause of gunpowder explodes, the significance of the offer is in itself cannot create a legal change, but it acceptance by the offeree which creates a legal relationship. Once an offer is accepted, it becomes a promise and cannot be withdrawn or revoked. An offer remains an offer so long as it is not accepted, become a contract as soon as it accepted. Rules of regarding a valid acceptance. Acceptance can be given only by person to whom offer is made. Means acceptance only given by the person whom offer is made. In case of specific offer, it can be accepted only by person whom it is made. Means जिसे ऑफर दिया है वही कर सकता है एक्सेप्ट. बोल्टन वर्सेस जोन्स 1857. If may I wrong, you will correct it. Train its group of. आप जो भी देख रहे हैं बढ़िया हैं. आप भी अगर तैयारी कर रहे हैं इसी चीज़ की तो छोड़ दीजिए, हम भी नहीं कर पा रहे हैं. मैं देख कमेंट आप भी कर रहे हैं तो छोड़ दीजिए, हम भी नहीं कर पा रहे हैं. ट्रेडिंग लॉस क्या लिखा है? ट्रेडिंग लॉस स्पेगुएटीज विद रेप ट्रेन इफ गुड्स ऑफ. ब्रो मैं समझ नहीं पाया आपने क्या लिखा है. मैं देख लिया लेकिन समझ नहीं पा रहा हूँ क्या लिखा है आपने. माफ़ी दीजिएगा कि थोड़ा हमारा इसमें कमज़ोर है. ये व्हाट्सएप लैंग्वेज ये सब थोड़ा कमज़ोर है, थोड़ा समझिएगा. व्हाट्सएप लैंग्वेज नहीं समझ पाते हैं. थोड़ा अगर आप हैं देख रहे हैं अभी तो थोड़ा ठीक से लिख दीजिए, हम पढ़ लेंगे. नहीं तो हमको डाउट रहेगा, हम पढ़ भी नहीं पाए कमेंट. चलिए अब तो कोई नहीं है, चलिए कोई बात नहीं. कौन है? हरी जोशी बाबा, पता नहीं भैया, कोई तो था. बोल्टन वर्सेस जोन्स. भाई कमेंट करो तो कम से कम 2-3 मिनट रुको, हम देख लें उसके बाद जाओ. ऐसे कैसे चले जाते हैं यार, बड़े निर्दयी लोग हैं. कर दिए और चले गए. हाय हेलो कर दिए और चले गए. अरे रुक जाते, हम पढ़ रहे थे आपका ही कमेंट और चले गए. कोई बात नहीं, छोड़िए, दूसरा बंदा करेगा तो पढ़ेंगे. थोड़ा रुक जाइएगा, 5 मिनट लगता है, 2-3 मिनट लग जाए तो बुरा नहीं मानिएगा. बोल्टन वर्सेस जोन्स. Bolton bought our business from Brocklust. Jones was Brocklust. Creditor placed an order of Brocklust for the supply of certain goods. Bolton supplies the goods even though the order was not in the name of Jones. Jones refused to pay Bolton for the goods because he entered into contract with Blockhurst. He intended to set off his debt against Blockhurst. As the offer was not made to the Bolton, therefore there is no contact between Bolton and Jones. Means if the contact was made by Bolton, then the Bolton. Bolton bought business from Brocklist. Jones, who was the Brocklist creditor, placed an order with the Brocklist. भाई भूख तो लग रही है यार मेरे को, ये क्या करूँ, तो भूख लगी. Acceptance must be absolute and unqualified. 5 बज गए भाई. मेरा कितना हो गया, 1 घंटा 23 मिनट हो चुका है बैठे हुए. कितना 1 घंटे 23 मिनट में मैंने कितना पढ़ा है, यहाँ से यहाँ तक पढ़ा है बस. कितने पेज पढ़ पाया मैं. अब 1 घंटे में इतने तो पढ़ लूँगा. 1 घंटे में इतने तो पढ़ ही लूँगा. वाइयो असला खाइयो. Acceptance must be absolute and qualified. As per section 7 of the Act, acceptance is valid only when it is absolute and unqualified, and is also expressed in some usual and reasonable manner, unless the proposal is prescribed the manner in which it must be accepted. If the proposal prescribes the manner in which it must be accepted, then it must be accepted accordingly. भाई मैं ध्यान नहीं दे पा रहा हूँ भाई, तो कमेंट में मेरे को थोड़ा ध्यान नहीं देना पड़ेगा भाई. आप कमेंट करो तो 5-10 मिनट रुक जाना, ठीक है. मैं पढ़ाई पे ध्यान दे रहा हूँ भाई. कमेंट पे बार बार मैं नहीं आके देख सकता, ठीक है. मैंने दूर रखा हुआ है और मैं बार बार आके उस पर ध्यान दूँगा तो भाई कोई फ़ायदा नहीं लाइव स्ट्रीमिंग का. मैं यहाँ नहीं बैठ के पढ़ पा रहा हूँ, ठीक है. इसलिए भाई कमेंट करना, कोई डाउट हो तो भाई वीडियोज़ है मेरी और किसी भी मैसेज कर देना, मैं बता दूँगा, ठीक है. बोल्टन हो गया. एक्सेप्टेंस मस्ट बी एब्सोल्यूट एंड अनक्वालिफाइड. मतलब एब्सोल्यूट एक्सेप्टेंस हम एक्सेप्ट करें कोई रिस्पॉन्स तो एब्सोल्यूट होना चाहिए, अनक्वालिफाइड मतलब मुझे इसमें हमारी कोई टर्म्स एंड कंडीशन नहीं है. एज पर सेक्शन ऑफ द एक्ट, एक्सेप्टेंस वैलिड ओनली व्हेन इट इज एब्सोल्यूट अनक्वालिफाइड. जैसा भी जैसा वैसा है, कोई इसमें चेंजेस नहीं किया गया है. एंड इट इज ऑल्सो एक्सप्रेस सम यूजुअल एंड रीजनेबल मैनर unless the proposal prescribe the manner in which it must be accepted. मतलब जिस प्रपोजल भेजा आपने आपको मेल पे, तो हमारा मन है कि आप हमको मेल चाहिए एक्सेप्टेंस से कि मैनर हुआ प्रिस्क्राइब मैनर, प्रपोजल प्रिस्क्राइब मैनर्स, ये मैनर हुआ, इट मस्ट बी प्रपोज, इट मस्ट बी एक्सेप्टेड. इफ द प्रपोजल प्रिस्क्राइब द मैनर इन विच मस्ट बी एक्सेप्टेड देन इट मस्ट बी अकॉर्डिंगली, मतलब उसी अकॉर्डिंग होना चाहिए, तभी वो वैलिड माना जाएगा. और वो नहीं हुआ उस अकॉर्डिंग तो वैलिड नहीं माना जाएगा. और जो भी चैनल पर लाइक सब्सक्राइब मतलब नहीं है वो लाइक सब्सक्राइब कर देना भाई. M offered to sell his lands to N. इतने बड़े मैं भाई ये सब नहीं पढ़ा, सॉरी. ऑफर पढ़ा, इन्विटेशन तो ऑफर पढ़ा, पढ़ लिया. कल होगा मनवा धरी रहा है मनवा तू पता ना पिया. The acceptance must be communicated. To conclude the contract, the parties, the acceptance must be communicated in some prescribed forms. Any contract, any condition, acceptance must be acceptance or acceptance with varying or two deviant conditions. No acceptance such conditions. Acceptance is counter proposal and has not to be accepted by the proposer. If the original proposal has to materialized into a contract further than a proposal is accepted, the offering must have the knowledge of the offering made to him. If he does not have the knowledge, there can be no acceptance. Acceptance must be related specially to the offer made. Then only it can materialized into a contract. The above point दोबारा acceptance must be communicated. To conclude the contract, the parties in the acceptance must be communicated in some specific form. Any conditions acceptance or acceptance with varying to relevant deviant conditions is more acceptance. Such conditions acceptance is a counter proposal and has to be accepted by the proposer. If the original proposal has materialized into a contract, further, when a proposal is accepted, offeree must have knowledge of the offer made to him. If he does not have the knowledge, there can be no acceptance. The acceptance must be related to the specially to the offer made. The only it can be materialized into a contract. The above point will be clever from the following examples. आया थोड़ा थोड़ा आया, थोड़ा थोड़ा नहीं आया. अब मैं करता हूँ ना फैक्ट. B supplier sent a draft agreement relating to the supply of coal to the manager of railway company with a metropolitan railway for his acceptance. The manager wrote the word approved on the same, but put into a draft agreement in the drawer into a table intending to set a company solicitor for a formal contract. Withdraw. By an overnight sight, the draft remained the drawer, and there was no contract as the manager is communicated. It has acceptance to his bad. When an offer made intent to offer, but without the knowledge that as an offer has been made without cannot be deemed to as acceptance thereto. Acceptance must be prescribed mode. Where the mode of acceptance is prescribed in proposal, it must be accepted in manner. But if the proposer does not insist on the proposal being accepted in manner prescribed after it has been accepted otherwise, that is not in the prescribed manner, the proposer is presumed to have consented to the acceptance. Time. Acceptance must be given within a specific time limit. If any and if no time is stipulated, acceptance must be given within a reasonable time and before the offer lapse with what is the reasonable time is now were defined in law and thus would depend on fact and circumstance on the particular case. Mere silence is not accepted. The acceptance of an offer cannot be implied from the silence of the offeree or his failure to the answer, unless the offeree has in any previous conduct indicate that his silence is the evidence of acceptance. Mere silence is not accepted. The acceptance of an offer cannot be implied from the silence. मतलब कोई भी एक्सेप्टेंस जो है वो साइलेंस नहीं लिया था. The acceptance of an offer cannot be implied from the silence of the offeree on his failure to the offer. The offer is in the previous conduct identified that his silence is evidence of acceptance. Acceptance by conduct or implied acceptance. Section 8 of the Act lays down that the performance of the conditions of a proposal is or the acceptance of any considerations for a reciprocal promise which may be offered with a proposal constitute an acceptance of the proposal. Proposal. This section provides the acceptance of the proposal by conduct as the against other modes of acceptance, that is verbal or written communication. Therefore, when a person performs the acts intended by the proposer as the consideration for the promise offered by him, the performance of the contract constitutes acceptance. ठीक है, समझ में आ गया. आगे communication of offer and acceptance. The importance of the offer and acceptance is giving effect to valid contract as was explained in it. Implied acceptance. Section 8 of the Act lays down that the performance of the conditions of proposal or the acceptance of any conditions for a reciprocal promise which may be offered with a proposal constitutes an acceptance of the proposal. This section provides the acceptance of a proposal by conduct as against other modes of acceptance, that is verbal or written communication. Therefore, when a person perform the acts perform the acts intended by the proposer as the considerations from the promise offered by him, the performance of the contract of the act constitute acceptance. Communication of offer and acceptance. The important of offer and acceptance is giving effect to a valid contract. Why was explained in the previous paragraphs. One important common requirements of both offer and acceptance as their effective communications. Effective and proper communication prevents avoidable revocations and misunderstandings between parties. When a contract between parties are face to face, there is no problems of communication. Because there is instantaneous communication of offer and acceptance. In such a case, the question of revocation does not arise since the offer and its acceptance are made instantly. The difficulty arises when the contracting parties are at the distance from one another and they utilize भाई जो भी वीडियो देख रहे हो भाई सब्सक्राइब कर देना चैनल को. The difficulty arises when the contracting parties are at the distance from one another and they utilize the service of the post office or telephone or email. In such case, it is very most relevant for us to know the exact time when the offer or acceptance is made. The Indian Contract Act 1872 gives a lot of importance to time elements in deciding when the offer and acceptance is completed. Communication to offer. The term section 4 of the Act's communication mm, of offer is completed when it is comes to the knowledge of the persons to whom it is made. Thus, it can be summed up that when a proposal is made by the post, its communication will be completed when the letter containing the proposal teaches the person to whom it is made. Mere receiving of letter is not sufficient. It must be received or read the message contained in the letter. He receives the letter on 12th March, but he reads it on 15th March. In this case, offer is communicated on 15th March and not 12th March. Communication of acceptance. There are two issues of discussion and understanding. They are the modes of acceptance and when it is acceptance complete. Let us first discuss the two issues of discussing and understanding. They are the modes of acceptance and when it is acceptance. Let us first consider the modes of acceptance. Section 3 of the Act prescribes in general terms two modes of communication, namely A by act and B by omissions intending thereby to communications to other. नींद भाई साहब सीधा बताऊँ जो भी चैनल पे देख रहे हैं भाई, सब्सक्राइब का बटन दबा दो। और कुछ भी डाउट हो क्या कैसे हो रहा है तो भाई कमेंट में पूछ सकते हो, ठीक है। ये है भाई लेमनेड वाटर। बहुत ज़्यादा खट्टा हुआ है यार, पूरे आत्मा काँप गई भाई। बहुत ज़्यादा खट्टा है भाई, लेट मी शो। लुक एट दिस, ये कितना नींबू लग रहा है। आधा नींबू डाला है मैंने बस, इतना रस है भाई इसमें। थोड़ी देर ही भाई लाइव स्ट्रीमिंग चलेगी, मेरा फ़ोन चार्ज नहीं है, so I have to charge it. Okay, let's start again. Communication offer. In the terms of the board here, the communication of an offer is completed or it is completed in order to the person to whom offer is made. ठीक है. It must be summed up as the proposal is made by the post. Its communications will be complete when the offer letter containing the proposal reach the person to whom it is made. May receiving the letter is not sufficient. He must be have reads the message consents in the letter. He receives the letter on 12th March, but he reads the letter on 15th March. In the case the offer communicated 15th March and not in 12th March. There must be two issues for discussion and understanding the modes of acceptance and what is acceptance when an acceptance is complete. Let us first consider the modes of acceptance. Section 3 of the Act prescribes in general terms two modes of communications. दो मोड होते कम्युनिकेशन के, ठीक है। The modes of acceptance, namely by any act and by omissions of intending, thereby the communication thereby to communicate to the offer or to the other, or which the has effect of communicating it to the other. Communication by act would include any expressions or word, whether would include any conduct intended by to communicate, like positive words or signs, so that the other person understands what the person acting making signs means to say or convey. Communications of acceptance by omissions to do something. Such omission is conveyed by conduct or forbearance on the part of one person to convey his willingness or essence. However, silence would not be treated as communication by omissions. Communication of acceptance by conduct. For instance, delivery of goods. For instance, delivery of goods at a price by a sellers to billings to a willing buyer will be understood as a communication by conduct to the conveyor. Acceptance. Communication of acceptance by conduct. For instance, delivery of goods at a price by a seller to a willing buyer will be understood as a communication by conduct to convey acceptance. Similarly, one needed to not explain why one boards on a public bus or drop a coin in a weight machines. The first act is a conduct of acceptance against its communications to the offer by the public transport authority to carry any passenger. एक मिनट रुक जाओ भाई, मेरा दिमाग खराब हो गया, कुछ समझ नहीं आ रहा। Communication is second by mission to do something. Such omission is conveyed by a conduct or by forbearance on the part of one person to convey his willingness or assent. However, silence would not be treated as communication by omission. Communication of acceptance by conduct. For instance, भाई जो भी देख रहा है लाइक कर दे, सब्सक्राइब कर दे। For instance, delivery of goods at a price by a seller to willing buyer would be understood as a communication by conduct to convey acceptance. Similarly, one needed There one may not explain why one boards or a public bus or drop a coin in a weighing machine. The first act is all conduct of acceptance. Insist communications to the offer by the public transport authority to carry any passenger. The second act is again a conduct conveying acceptance to use the weighing machine kept by the vending company as an offer to render the service of a consideration. The other issue in communication of acceptance is about the effect of an act of emissions. Conduct these indirect efforts must result in effectively communicating its acceptance or non-acceptance. If it has no such effects, there is no communication regarding mostly of which the acceptance thinks about the offer within himself. There on mine would not amount to communication where a resolution passed by a bank to set Lancet to A remind communicated to A. It was held there was no communication and hence no contract as against the promisor when it is put in the course of transmission to him so as to be out of the power to of the acceptance to withdraw the same. The against acceptor the against as against the acceptor when it comes to the knowledge of the promisor. When a proposal is accepted by a letter sent by post, the communications of acceptance will be completed as against the proposal when the letter of acceptance is proposed and as against the acceptance when the letter is the proposal. For instance, in the following example, if we accept A proposals and send his acceptance by post on 14th, the communication of acceptance as against A is the complete as against A is complete on 14th, that is when the letter is posted as against B. Acceptance will be complete when the letter reaches A. A. Here A the proposal will be bound by B acceptance even if the letter of acceptance is delayed in post or lost in transit. Give an example. As against the proposer, when it is posted in the course of transmission course of transmission to him so as to the out of the power of the acceptance to withdraw the same. Withdraw the same. As against the acceptance, when it is came to the knowledge of proposal, when a proposal is accepted by the letter signed by post, the communication of acceptance will be completed as against the proposal. When the letter of acceptance is posted is against the acceptance when the letter reaches to the proposal. On the instance, for example, the B accepts A's proposal and signs his acceptance by the proposal on 14th communications of the acceptance as against A is complete on 13th, then that is when the letter is posted as against B. the proposal will be bound by B acceptance even if the letter of acceptance is delayed, imposed or lost in transit. The golden rule is proposed to become bound by the at the moment acceptance posted the letter of acceptance, but it is necessary that the letter is correctly addressed, adequately stamped and duly posted. In such an event, the loss of a letter in transit, the wrong delivery, non-delivery, etc. will not affect the validity of contract. However, from the viewpoint of the acceptor, he will mm, can't. He will be bound by his acceptance only when the letter of acceptance has reached the proposer. So it is critical in this case the letter have been completed from the viewpoint of proposal but not from the viewpoint of acceptance. Of course, in awkward situations of only one party to the contract will treated as a bounds by the contract. No one can would be sure as to the where the letter of acceptance had. Atta. Yeah. चलो भाई लाइव स्ट्रीम करते हैं एंड ओके